Good evening. This is a terrific turnout. So glad to see so many of you. If you're still looking for spots, come on in. No lines, no waiting in the front row. That's what happens when you come late. Welcome. Hi. Good evening. I'm Amanda Reed. I'm Faculty Co-Director for the Center for Media Law and Policy, and welcome to First Amendment Day. This is the 14th Annual First Amendment Day here at University of North Carolina at Chapel Hill. And I would like to welcome you to tonight's event, Regulating Big Tech and the First Amendment. Tonight's event is an exciting partnership between the Abbey Speaker Series, the Center for Media Law and Policy, in honor of our First Amendment Day. The Abbey Speaker Series is hosted by the UNC Program for Public Discourse, which seeks to build our students' capacity for debate and deliberation, and to foster a culture of constructive dialogue about issues of national importance at UNC and beyond. 4 times each year, the Abbey Speaker Series brings together experts from different fields and disciplines to showcase productive dialogue on timely issues across a range of perspectives. Given that civic discourse requires freedom of speech, tonight's event on First Amendment is in keeping with the goals of the Abbey Speaker Series. On behalf of the university, I would like to thank the Abbey family for helping bring such an important program to campus. The UNC Center for Media Law and Policy is an interdisciplinary center run jointly out of the UNC School of Law and the UNC Hussman School of Journalism and Media. Tonight's event is the culmination of a fascinating day-long, campus-wide First Amendment Day organized by the center. Tech regulation and the First Amendment is a big topic, and I expect tonight's conversation to cover a range of issues, including Section 230, social media content regulation, and efforts to protect minors from potentially harmful online content. I'm looking forward to a lively conversation, as I know our panelists have different perspectives on many of these issues. And I am proud the UNC is hosting such an important conversation. I will now turn to the University of North Carolina's Chapel Hill's Bowman and Gordon Gray Term Professor and PPD Faculty Director, Sarah Truhl. She will tell us a bit more about the panel. Thank you.
I've been told to switch mics. Hopefully this one works. Thank you very much, Amanda. As Faculty Director of the Program for Public Discourse, I also want to thank Nancy and Doug Abbey for making tonight's event possible. Additionally, we are grateful for the support of our co-sponsor, the Center for Media Law and Policy. Both of our panelists have been involved in public discussions and litigation related to tech regulation. Carrie Goldberg is a victims' rights attorney and founder of victims' rights law firm C.A. Goldberg, which fights for survivors of stalking and sexual violence and represents victims of injuries caused by tech products. Among the firm's better-known clients are Weinstein accusers, Hollywood stars, and a member of Congress. But some of Carrie's proudest successes are the ones that stay out of the headlines. Recoveries for adult survivors of child sexual abuse and restraining orders for victims of stalking. Carrie is also the author of Nobody's Victim, Fighting Psychos, Stalkers, Pervs, and Trolls. Welcome, Carrie. Eugene Volokh is the Gary T. Schwartz Professor of Law at UCLA School of Law. He is also currently a visiting fellow at the Hoover Institution at Stanford, where next year he will be a senior fellow. He specializes in First Amendment law and technology. Prior to becoming a professor, he clerked for Supreme Court Justice Sandra Day O'Connor, and recently he was a plaintiff in Volokh versus James, a lawsuit that ended up blocking New York State's hateful conduct law, which required social media platforms to provide mechanisms for reporting hate speech. The founder and co-author of The Volokh Conspiracy, a weblog currently hosted by Reason, Eugene also worked as a computer programmer for over a decade. Our moderator, Mary-Rose Papandrea, is a Samuel Ashe Distinguished Professor of Constitutional Law here at UNC's School of Law. After law school, she clerked for multiple judges, including U.S. Supreme Court Justice David H. Souter. She then practiced law for several years, specializing in First Amendment and media law litigation. At UNC, she teaches a range of courses, including First Amendment and media law, and she serves as a faculty symposium advisor for the First Amendment Law Review. Thanks again to our distinguished panelists for being with us tonight. I think you will find tonight's conversation lively and informative. If you are still looking for a seat, there are some more scattered among the crowd here, so feel free to come in. We do seem to have a very popular event on our hands, and we're looking forward to a great evening. Now I'll turn it over to Mary-Rose.
Great. Thank you so much, Sarah and Amanda. Thank you to the Program for Public Discourse and for the Center of Media Law and Policy, which has been hosting First Amendment Day for so many years. It's such a wonderful day. As Amanda said, this is a really big topic, and there's no way we can cover everything in 1 hour because we're also going to have 30 minutes of Q&A. So you can start getting your questions ready. You will want to write them down on a card, pass them to the end of the aisle. We'll start collecting them around 6:15. I want to get started with an opening question, first to Carrie and then to Eugene. In discussions about the regulation of big tech, how would you situate yourself, and how do you characterize your approach to the various legal issues that arise in this space?
Okay. First of all, I'm so happy to be here. This is my first time in Chapel Hill, and I guess the weather is probably always like this, which makes it more impressive that you all are here. I mean, okay, so the question is, what's my approach? I want to just start out by saying that, I think Eugene and I were chosen for having a lot of diametrically opposed views, but I am definitely a big fan of the Constitution and the First Amendment, although this is my first time ever actually celebrating the Constitution. I'm even being sanctioned right now in one of my cases for some free speech issues that I did on Twitter or X. So I come to this conversation through the lens of a litigator. I have a law firm in Brooklyn, as we talked about, that does cases all over the country. And many of our cases, if not most of them, are for clients who've been catastrophically injured from tech-facilitated things. I'm going to be talking about some of my cases. They involve suicide, child sexual exploitation, image-based sexual abuse. I just want to get that out there because my cases, although I'm not going to be going into graphic detail, I can't really approach this topic without talking about my clients. But anyways, my biggest cases usually come head-to-head with Section 230. I litigate for something that I believe is conduct-based, but anytime my defendant is a tech company, then they're almost always going to plead Section 230 and use that as a means to win a motion to dismiss and throw my cases out the door.
So I'm very, very pleased to be here. Thanks very much for having me. I teach a whole class on First Amendment law, 2/3 of it. So basically, I don't know, probably some 40 hours are on First Amendment. So it's a complicated law, the First Amendment is. The text is simple. The law is complicated. It's complicated law for a complicated world. It's hard to boil down the First Amendment into one simple principle that applies everywhere. So I generally take a pretty capacious view of First Amendment protection, but of course certain kinds of speech is not protected by the First Amendment. Classic example, libel. False statements of fact, especially knowingly, although sometimes negligently false statements, that damage a person's reputation, unprotected by the First Amendment, and that's well established. And there are other examples as well. So I recognize that the First Amendment doesn't protect everything, but it does provide very broad protection, especially against criminal punishment and civil liability. In particular, it provides protection even against speech that causes harm. For example, a lot of the really prominent Supreme Court cases have been about advocacy of violent revolution, advocacy of crime, and generally speaking, that's protected. If you think about it, virtually any kind of political crime the September 11th attacks, to give one example. For that matter, in other countries, the rise of the Nazis or the rise of the communists, all led to tens of millions of deaths, and, the latter two did, and September 11th attacks, obviously, several thousand. All of them were promoted by speech in some measure. If you look at it from the kind of retroactively, you look at a particular violent act, if it's a political act, it's likely be some speech in the background. But that doesn't mean you can ban advocacy of communism, or for that matter, advocacy of Nazism, or advocacy of extremist Islam. The First Amendment protects even that. The other thing to keep in mind, and we mentioned Section 230, is that there is this federal statute. It's not required by the First Amendment. It was enacted by Congress in the mid-1990s, which is generally called Section 230. It's Title 47 of the U.S. Code, Section 230, that provides some extra protection for online intermediaries, things like social media platforms like Twitter and Facebook and such. Also others, like, for example, my blog, which has comments. And what it says is, even when speech is constitutionally unprotected, for example, it's libel, or if it's threats of violence, true threats of violence or some such, the intermediary is immune from state criminal and state civil and much, although not all, federal criminal and civil liability for things there. That's what allows, for example, Twitter to, and I'm not going to call it X, it's still Twitter to me, allows Twitter to keep up posts even when somebody says, oh, that's false. You know, Twitter can say, it's not our job to determine what's true and what's false. If you want to, you can sue the poster, and maybe we'll turn over information that will help you identify the poster. You can sue the poster and get damages or maybe even an injunction, but we're not going to take it down just on your say-so. So we are living in a world where when it comes to online speech, both the First Amendment and Section 230 are tremendously important. And of course, there's been talk about modifying or repealing Section 230. It's a lot easier to do that than modify or repeal a constitutional amendment. And there are plausible arguments in both directions about that. But it's important to realize that some of what we're going to be talking about is First Amendment protection required by the Constitution, and some of it is provided by this congressional decision from about now, almost 30 years ago, that enacted Section 230.
All right, so Eugene and Carrie, you both mentioned Section 230, so that is going to be our first topic of 4 topics. It is statutory, it is not the Constitution, but it does provide an important type of protection for the tech companies, and so I want to explore that. And Eugene, the first question I have for you is, when Section 230 was passed in 1996, it was seen, at least by some, as essential for the growth of the internet. Do you believe that Section 230 has been a good thing for society, a bad thing for society? And I'm particularly interested in hearing whether your views about Section 230 have changed over time.
Well, it's hard to know for sure. You know, it would have been really nice if they'd done things scientifically. They'd split the country into 2 halves and enacted Section 230 in one, enacted in the other, and because it has to be double blind, didn't tell either half which they were, right? Well, you can't do that, right? All we have is the current world. We don't have a counterfactual world in which Section 230 was not enacted. Let me step back and mention Section 230 basically has 2 principles. I oversimplify here, but basically one of them is platforms have the right to remove material that they view as harassing or lewd or excessively violent or otherwise objectionable. That's actually very much in play with regard to these Texas and Florida statutes that are now going to be before the Supreme Court. The Supreme Court just on Friday agreed to hear the cases involved in them, which ban platforms from discriminating based on viewpoint with regard to their users. That's an interesting issue. I'm going to set it aside for now, because the thing that I think we're going to be mostly talking about is the part that says that platforms are also immune from liability as speakers or publishers as to things that they do allow. So I started with they're allowed to block certain things, but they're also allowed to host certain things without fear of speaker or publisher-based liability. So the classic example, which was a deliberate choice by Congress, has to do with libel. Again, libel is generally false statements of fact about people that damage their reputations. And Congress decided, look, platforms, unlike newspapers, should generally not be liable for material that's published on the platform by third parties. A newspaper, if it publishes a letter to the editor that accuses someone of something, or publishes an op-ed, or even an advertisement, they could be liable for that. They have some protection, but not unlimited protection. But when it comes to social media platforms and other online entities, like Google Search, for example, they are immune. So one interesting question is that a good idea? So, right, so one argument, so here's why it's difficult. On one hand, the consequence of this has been indubitably a lot more libel. Again, you could still sue someone for libeling you online. You just have to sue that person. But you'd have to find that person, and then you'd have to ask yourself, does that person have any money to pay me? And if they don't have any money, then, you know, there's no prospect of you recovering the costs of your lawsuit. So no lawyer would take it on contingency. You might not be willing to pay tens or even hundreds of thousands of dollars out of pocket. And what's more, what if the person is anonymous in a way that you can't penetrate? Or the person is overseas and it's very hard to get a judgment against them. So what you'd like to do is be able to sue the social media platforms, but the social media platforms are immune. Well, all right, so, well, that's the downside. What's the upside? Well, imagine you post something sharply criticizing someone. So we're talking about allegations of sexual misconduct by powerful people in Hollywood and elsewhere. So somebody posts something that says, oh, this person raped me, or this person threatened to fire me if I didn't sleep with them. Then that person could sue you, but without Section 230, what he'd probably do is he'd say, oh, this was posted on Twitter. I'm going to threaten to sue Twitter. I'm going to demand that Twitter take it down, or else I'll sue it. And Twitter will probably say, look, we can keep it up, in which case we risk the possibility of millions of dollars in damages and hundreds of thousands of dollars to defend ourselves. Or we could take it down, in which case we'd annoy a user and maybe some other users would protest. But we'd say, look, we had to do it because we were facing the risk of liability. In those kinds of situations, the platforms would generally err on the side of taking it down, right? In fact, they might err on the side of proactively, even without a demand, blocking certain kinds of things, and especially with AI these days, easier than before to identify what seems to be an accusation of misconduct because they'd be afraid of legal liability. Or to give another example, let's look at the Scientologists. It's a group that's controversial, and I think rightly so. It's also known to be quite litigious. Imagine somebody posts something sharply criticizing the Church of Scientology. And they, again, go to, after, let's say it's Facebook this time, or Google as to YouTube, and they say, look, we're going to sue you. We have all of these lawyers. It's going to cost you millions of dollars or hundreds of thousands, again, at least to defend yourself, maybe millions of dollars in damages, because we claim that this is libelous. And it's true that the speaker says, no, it's perfectly true. Well, all right. Do you really want to risk it, Facebook, Google, Twitter? And I think in many of those situations they'd say, no, we'd rather not. So again, they would err on the side of taking it down and maybe even just prophylactically blocking anything that appears to be criticism of highly litigious organizations. If you don't want to focus on Scientology, how about Disney?
I want to stop you there. Sorry.
Understood. So that's the plus and minus.
But so Eugene, I don't blame you for focusing on defamation because there were two, not to get into the weeds, but that was, I think, what prompted perhaps the passage of Section 230. But Carrie, what have you seen Section 230 do, and what are your concerns? Putting aside defamation for just the moment, what concerns do you have about what Section 230 does and its protection for these tech companies?
Here's the thing. For centuries and centuries, we've had this thing called lawsuits. You know, if somebody harms you, then that person should have to pay for your harm. And it's worked really well. And it makes zero sense that there's an entire industry which at this point has grown to become the most powerful, omniscient, omnipotent, wealthy industry in the history of the universe, that that suddenly that this entire industry is immune from liability for harms they've caused. So, back in 1996, when Section 230 was enacted, it made a little bit of sense. At the time, the main lawsuits against platforms related to defamation and obscenities and publishing torts. And the idea was that we don't want these very basic platforms to be liable for content that they don't even know about. But we're in 2023, and we're walking around with, in everybody's pocket, things that are way more powerful than the most sophisticated computers were back then. And our apps, have geolocation, there's AI, there's algorithmic recommendations. These are complicated products. These are not just dumb conveyors or conduits of information. They are complicated products that can really cause serious injury. And so, it's basically the equivalent of a tax break that this one industry, unlike cars, airplanes, baby cribs, all these other products that can do harm and have done harm, this industry just gets this tax break. And what we've seen is that Section 230, instead of empowering platforms to feel liberated to remove content they don't like without getting sued, instead, platforms have seen it as we can't be held liable if we keep content up. And we can't be held liable if we release this product without even doing any sort of basic test on how it's going to be maliciously used. So I think it's created a real imbalance in the marketplace, and we have, there's nobody that can't be injured from tech, and I represent, children who've been horrifically sexually exploited. I represent families whose children purchased a suicide kit off of Amazon. I have 40 of those cases. Amazon is pleading Section 230 for its right to sell suicide products to 16-year-olds. Omegle, in one of my cases, pleaded unsuccessfully to be immune. It was actually one of the only cases in the country where we made a successful argument that this online platform was a product and not a service, and that the mechanism of matching children and adults for video string chatting was actually a product defect, and so we overcame a motion to dismiss. But the point is that there's all this really lofty conversation about Section 230 and speech and stuff. The fact of the matter is, this is a legal, procedural thing. It is just a boring motion to dismiss,
I teach civil procedure, so.
It's freaking exciting, but for some of us. But this is just civil procedure, and it's not even companies don't even have to show that they are entitled to Section 230 in order to be able to put it into a motion to dismiss, because it isn't even something they have to plead. They just get to argue it. And just based on that, cases that are very legitimate with very extreme harms just get thrown out of court.
Oh, thank you, Carrie. So the cases you have, are some of them defamation? It seems like, from what I've heard, they range beyond the defamation context into harassment and abuse and other sorts of things.
I know better than to sue platforms for defamation because it is, Section 230 only applies to content. And so some people would call it trying to skirt Section 230, but I consider it just using creative litigation tactics to try to find little mouse holes that we can go down. And so I've been taking this product liability approach, saying, okay, well, I'm not suing this platform for any content that another user posted. I'm suing this platform for having a defective product. And there was resistance in the Second Circuit, and now it's really being embraced in the Ninth Circuit.
All right, so before we do want to talk a lot about
Yeah.
that case, because you are litigating that, and there are a lot of meaty First Amendment questions in that. Before we move on to that, I just want to give you an opportunity to talk about ways you would like to see Section 230 amended. And just for the audience, we had decided not to spend too much time parsing through the current Section 230. We could have put up a slide and argue about the words and what they mean, and lawyers do that, and they are doing that, and Carrie's doing that, but instead, I thought we'd talk about the very live debate about how should we amend or maybe repeal Section 230. So what are some of the ideas that you have specifically, Carrie?
Okay, so my first choice is not to amend it at all, but instead to use case law and to win Section 230 all the way up to the Supreme Court, and then it's just resolved as a matter of case law, and it is reduced back to the publication tort that it was intended to be back in 1996. That is my first choice, and it might happen. But my second choice, of course, is to get legislators to act. And the thing is, like, for any of you future litigators, it's really cool to have the power as a plaintiff's attorney for you and your client and your good legal theory to actually potentially be able to change the law of the land. Legislation is a whole sausage factory where you have to have all this consensus and you have to be tugging people's sleeves and getting them to do you favors, and it never turns out how you want it to be. There's so many compromises. So I'm going to tell you how I want it to be. If I could, like, you know, if I had a magic wand. So most importantly, I think that we have to be looking at the products and platforms and distinguish between those that just host defamatory content versus those that enable criminal conduct. So if the main purpose of your platform is to match children with predators, and that's how it's used, then it should not get Section 230, regardless of whether there's a product liability argument or not. But then there should also be, like, carve-outs for bad Samaritans. So if a platform just has their head in the sand and says, well, you know, if they're a dating app that lets children, that markets to children, and then says, oh, well, we didn't know that children use this app. Like, it says that it's 18 and older, but you're marketing to children. If their head is in the sand and they're trying not to know about the harms that are happening on their platforms, then that should not get immunity. We can't have, like, the willful blindness to illegal things. We also need there to be no immunity in situations where there's a court order. So I have a case where my client was viciously stalked on Twitter and a lot of other platforms. Her ex ended up making bomb threats in her name and doing all this really vicious stalking. He gets arrested. He's in jail. He smuggles a phone into jail, contraband, and continues to tweet about her on Twitter. She has an order of protection. Twitter would not honor my order of protection and the fact that there was all this very provable court record about this man's abuse of my client on Twitter, and he was federally incarcerated. They would not remove these harassing tweets, even though, like, there was court orders and like, he was arrested for his conduct on Twitter. That's stupid. So like, when there's, like, obvious court orders or obvious notice to the platform, they shouldn't get this immunity. There also shouldn't be immunity for, like, the most egregious stuff that happens on platforms, the most egregious content, which is child sexual abuse material, content that is all about stalking, terrorism, the types of content that Section 230 was never intended to protect. And then I don't feel that they should get like any sort of carve out, or I don't think they should get any immunity in situations where they're being attacked for the product and the operations of it, or for their own terms of service. Like right now, companies can say that they don't, you know, they can post all these terms of services and all these promises that they make to consumers. But Section 230 actually protects them from any obligation to abide by those promises. So, you know, there are a few other things like algorithmic recommendations. That is clearly not third-party content. That is machinations of the platforms themselves. They shouldn't get protection from that.
Thanks, Carrie. So Eugene, there's a lot of possible reforms, and we can't take on all of them because this is only topic one, and we do have to, you know, move to the products liability case in a moment. But if you can just respond, do you agree that we should rewrite Section 230? I mean, putting to one side Carrie's fervent dream that we get a court decision that limits the current Section 230, but barring that, do you think that that Congress should pass an amendment that would address harassing speech or abusive speech or speech that promotes child abuse, that sort of thing?
So there's a lot going on there, and for many things, the devil is in the details. So just to give an example, harassing speech, people use the term harassment a lot, and actually the law sometimes does too, has lots of different meanings, most of them pretty vague. So I'd need to know more about what harassing speech is. For example, some people say harassment when they're being constantly criticized online. Could be constitutionally protected criticism or abusive speech. I'd have to know what you mean by abusive speech. Likewise, you know, it's an interesting question with regard to, say, child sexual abuse. Well, certainly child porn is already exempted from Section 230, at least as to federal prosecutions. So there's a lot at stake for companies like Twitter and Facebook when it comes to child porn. They know that they need to take it down, otherwise they could be criminally prosecuted by federal prosecutors. Nobody likes that. On the other hand, if you're talking about speech that kind of facilitates other kinds of misconduct, or maybe even allows adults and children to talk to each other and meet up, you know, there's an interesting First Amendment question. To what extent can that kind of speech be restricted? I just wanted to step back and talk about a broader point. And that's all about police. And whom do you want to police you? So right now, we all know that if we say certain things online, a very narrow range of things, we could get into legal trouble. Libel, as I said, is one example. So you could be policed by the court system, essentially. You might have to police yourself because of the threat of liability. True threats of illegal conduct. You threaten to violently attack someone, that could be criminally punishable. You could have the police knocking on your door for that. Or solicitation of crime against a specific person. If you post something saying, this police officer ought to be killed and all of you, if you ever run into him, should attack him. Well, that is unprotected solicitation of a crime against a particular person. And again, you could be, the police can go after you. What would normally not happen, not always, I mean, sometimes it would happen, but normally not happen, is that you're being policed by the platforms. They do police certain things that they choose to do under the terms of service, but for a lot of things like libel, they say it's not our business to determine what's an accurate allegation and what's not. It's not our business to determine when some criticisms of somebody become harassing or abusive. That's not our job. Go to the police, go to the courts. You can get remedies against the speaker there. We're not going to be doing that. It's only Section 230 that allows them to say that. If Section 230 were repealed or sufficiently constrained by the courts or otherwise modified, they would have essentially, practically speaking, an obligation to police your speech online. Obligation to, whenever somebody, for example, says, oh, this is libelous, and you're putting your head in the sand by ignoring this libel, they'd have to say, okay, fine. We need to either investigate to determine whether it's true or false, or, again, since it's very hard for them to know whether some allegation is true or false, we need to take it down. So if you trust the platforms to police it, and you want them to police it more, Section 230 is worth cutting back. If you don't like being policed by them, Section 230 is pretty important.
I understand, and I wanted to steer us away from libel just for the moment,
Sure.
just because.
But it's
in the
tremendously
sphere-
important.
Oh,
Yeah.
absolutely, but maybe we have agreement that it might be problematic, maybe not, I don't want to put words in your mouth, if we required the platforms to be responsible for defamatory speech. But putting that to one side, I think Carrie's litigation focuses a lot on harm to children and the grooming of children by adults and dangerous kinds of things. So about that, or maybe you could articulate it better, but would you be, if Section 230 had an exception for, what would be a good exception? I guess the devil in the details, but trying to protect the adults from grooming children for illicit sexual relations or illegal sexual relations. Would that be problematic? To say, like, if that happens on your platform, you will be responsible?
Well, so again, let's look at it from the policing perspective. So let's say you have a conversation with, let's take an example. Let's say you're gay and you have a conversation with a 16-year-old. Let's say you're 22, this person is 16, and you have online conversation. And the person says, I think I'm gay. You say, this was kind of my life, and you start talking to them. Of course, you know that at some point, especially, I assume the age of consent is above 16, and actually most of the country it is 16, but just my hypo is 16, let's say the age of consent is 18. Obviously, if at some point you say, hey, let's get together for sex, that's a crime. It is a crime of attempted child molestation or solicitation of, there are well-defined criminal provisions for that. And you could be prosecuted for that, and you could be sued if it turns out that you do actually engage in sexual conduct with a person, then that could be cause for civil liability as well as the criminal liability that you probably most worry about, and rightly so. There is an age of consent, and you can't do that. Now let's see what happens if a social media platform might face criminal or civil liability for that sort of thing. So somebody complains saying, in this discussion group, there's all of this talk about sex, and it's addressed to 16-year-olds. And I think they could say, no. We've looked at it very, very closely. We don't think any of it is actually attempt to get someone to have sex with them. It is discussions of sex, but it's okay to talk about sex, at least in non-highly pornographic term with minors. We're going to defend the rights of our users to continue this conversation. Or the platforms could say, this is too risky for us, whether from the civil side or the criminal side. We don't get anything out of it. Our users get something out of it. We get very little out of it. So we're just going to say that whenever somebody complains about some online discussion group where there appear to be adults and minors talking about sex, we're just going to shut it down prophylactically because, this is what it takes to avoid liability. So again, it's a question of, do you want the platforms policing that, or do you want to leave policing that to the police or to the courts enforcing civil liability rules against the people who are actually engaging in this behavior? So that's an interesting question, but I think that's the way you should think about it.
So Eugene, you are so clearly a law professor because you set it up. It could be this way, could be this way. What do you think? What do you think, Eugene? Do you think that do you think it would be possible to craft or rewrite Section 230 to address the concerns that Carrie has? Or do you think it's like a fool's errand?
We need to look at it case by case. So just to take an example, what most people call revenge porn, what probably is more accurately called non-consensual pornography, which is when somebody posts pornographic images of another person without that person's permission for the posting. I think if you were to say there's going to be that the platforms could be liable under existing torts, probably disclosure of private facts would be the key such example. There would be a chilling effect, but it would be mostly a chilling effect on porn. There's plenty of porn online. I'm not against protection for porn, but to the extent that it means that platforms overtake down certain kinds of porn images, you might say, not a huge problem. On the other hand, if platforms could be held liable on some negligence theory for any kind of harm that could happen to a child as a result of conversations that the child has with an adult, then I would think that would have a too high a chilling effect on both the speech of adults and the First Amendment rights of children, which are actually quite significant, as the court has told us. So I think a lot depends on the particular details. Again, likewise, there is an exception to Section 230 already for criminal law enforcement of federal child porn law. Doesn't seem to have been unduly chilling, although you could imagine some other exception being unduly chilling.
I'm going to jump in here because,
Sure.
you know, there's a lot of talk about these exceptions, you know, for federal crimes. The fact of the matter is that DOJ has never brought a case against an online platform. So it's academic. What I hear you talking a lot about is content.
Yes.
Okay. There's also a lot of conduct that these platforms are doing. I'm not particularly concerned about content, defamation. I'm not going to sue a platform and spend hundreds of thousands of dollars for somebody, you know, being called a bitch or a pedophile on Twitter. There's just not enough harm. Most lawyers would not take that case because there's not enough damages. You're never going to come out even. And that's a calculus that all plaintiffs' lawyers have to do. We're not just, you know, doing cases for fun. We actually have businesses. And so there's already a lot of hurdles for any case that is going to be brought. Not to mention Iqbal v. Twombly, that there's just very high pleading standards in most cases. So but I'm really concerned about conduct. So take, for instance, our case against Grindr, our first case against Grindr, where my client, his ex, was impersonating him on the platform and sending as many as 23 human beings in real life to his home, to his gym, to his workplace, all tricking these people into thinking that my client wanted to have unprotected rape fantasy sex with them. My client flagged it for Grindr over 50 times. I sent Grindr a cease and desist letter. I got a temporary restraining order against Grindr requiring that they ban this abusive user. But what happened was Grindr came to court and said that they didn't have the technology to ban a user, and that anybody that, you know, if they banned a profile, that person could just create a new profile and start using the app again. Its competitors were able to ban this user, but not Grindr. So it wasn't even at the standard of care. And so we sued Grindr for having a defective product because it's an arithmetic certainty that if you have a dating app that facilitates in-person sexual encounters, that sometimes it's going to be used by predators, by stalkers, and people are going to be harmed. That whole theory was completely about the product and the conduct of the platform. I didn't even know what content was at play here. Grindr never released the information about what was on the profiles or what was in the DMs between the offender and the person. There was no publication of material that we were suing about. However, the judge said that was protected by Section 230 because at the most basic point, it was content-based because this offender had created content that then led to these harms. That theory, or that judge's decision has not been embraced other places any longer. But I mean, what do you think about that?
Well, so first, I think this just highlights the importance of identifying closely the terms, whether it's harassing or abusive or content versus conduct. So the claim was that Grindr should not allow false claims that I am this person, I want to have sex with random strangers. That is a claim about content. If the content were true, or if it were something unrelated to sex, then in that case, presumably there'd be no objection. The objection is that speech of a certain content, in particular false statements impersonating a person, can lead to harmful conduct, but of course that's true in a wide range of speech restrictions, right? If the government wants to ban advocacy of violent revolution, it's because it's afraid that this content will lead to harmful conduct. So I don't think the distinction between content and conduct really works here. The argument here, in the case you're describing, is all about supposedly harmful content. In fact, actually harmful content. Now, the Section 230 approach in these kinds of situations is, generally speaking, that the content may be, in fact, be constitutionally unprotected, and could be on a variety of theories, but the right approach is to sue or to get criminal law enforcement against the speaker. Not against the platform, but against the speaker. Presumably there's somebody there who did this bad thing, and they could be arrested, they could be sued, and the like. So Section 230 says that's really all you've got. Now maybe you should have more. Maybe you should be able to get it, to get liability against Tinder. But again, then you'd need to ask. So I haven't followed closely the details of that case, but I take it that Tinder's objection was people can set up new platforms in part because we don't verify people's identities. Like somebody could set up a new platform claiming to be some other person, and we don't try to check whether that's really that person. And I take it they have a reason for it, right? Presumably there are a lot of people who aren't terribly who don't feel terribly secure using a platform where having to do with sex, having to do with anonymous or non-anonymous, let's say, having to do with sex with many partners, and in particular, for example, having to do with gay sex, they may not feel comfortable identifying themselves to the platform and having this online trail, which could then be accidentally leaked, as in fact has happened to sex-related platforms and the like, or hacked into and such. So one possible answer is, well, too bad for you. Dating is potentially harmful behavior, in that people using these dating platforms can sexually abuse people or can lie about people that could lead to potential sexual abuse, and therefore you got to identify yourself. Like, you have to show your ID to buy alcohol, which is potentially harmful. You should show your ID or otherwise identify yourself to a service like Grindr. But I take it there's a counter-argument that maybe that shouldn't be so. Section 230 says that's left to the platform to decide. And again, the enforcement would be against the person who posts things and not against the platform. Do we like it or not? Good arguments both ways. But again, you have to recognize that by threatening the platform with liability, you're essentially requiring it to do a lot more policing of its users. And that has a spillover effect, not just on the bad users, but also on some of the good users, the people who do want to be able to use these platforms, for example, anonymously.
Carrie, I would like to give you a chance to talk more about your products liability theory. So Carrie is part of a big case currently pending in the Northern District of California asserting products liability claims, negligence claims, and other tort claims against the platforms. And I'll let you take it from here and tell us more about this litigation. And then, Eugene, you can respond. And just for the audience, we are going to move away now from Section 230 as fun as it has been, but we're going to talk more about the First Amendment and tort issues involved in this litigation.
I mean, this is still a Section 230
Oh,
case.
it certainly is. And to put it to one side is very fake, but
it's going to be very difficult to walk away from this conversation. Okay, so there's a very big, for the first time ever, there's a multi-district litigation against tech platforms. And so when I was a student, I'd never even heard of MDLs, but basically it's a type of mass tort where all the plaintiffs have had similar experiences against the same defendants. And it's kind of like a class action, except that instead of it being an entire class, you have lots of people with individual cases. And so usually what happens is that they all get consolidated into a multi-district litigation, and then there's a judge appointed that just kind of figures out sort of the things that are going to be common for all the cases, like some of the discovery issues, whether it passes First Amendment muster, whether it's going to be immune from Section 230. And so that's happening right now against TikTok, YouTube, Meta, and Snap. So we've got 4 defendants, and all of the allegations relate to the idea that these platforms are inducing addiction. and that children are getting addicted because of the algorithms and the nudges and all of the technology that is inherent to the product. And so it's a very active case right now. There's going to be an argument like later this month about whether Section 230 is going to apply and whether the First Amendment is going to apply. Of course, our defendants obviously say that they're immune because of Section 230, that this is all content-based, and that this is, that platforms are protected by the First Amendment. But on the flip side, all the claims, relate to whether or not, these products were defective and whether there was negligence in the manufacturing of the product. And just one more thing about Section 230 is that, because it is one of the biggest obstacles in this case, is that Section 230 says that the claims must be what treats the internet service provider as the content producer. So it's not really what what somebody else wants to, like, for instance, you said, well, that's content, like the Grindr case is all content. No, the question is, what do the claims treat the platform as? So in Grindr, they did treat the platform as a product, and this is a defective product, and everything related to the product. And that's the same thing that's happening with the social media addiction cases, is that these are product cases. MDLs typically always are product-based. So you've heard of the 3M earplug cases and the vaginal mesh cases and the Johnson & Johnson's talk cases. Those are all the types of cases that are MDL, and it's about the product.
And just for the audience who doesn't know about can you just say a word about the allegations about the addiction?
So the plaintiffs are all people who were using social media as children and developed eating disorders from algorithms recommending content to them, and developed suicidal ideation, in many cases died by suicide, again from algorithmic recommendations of content, and it relates to like on the YouTube platform, it relates to the platform choosing and selecting the material that was presented to kids, and predicting what they would want to see based on their user history, or auto-playing the next video, which would be even more addictive or violent or triggering content.
Great. So, Eugene, I beg of you, we're not going to talk about Section 230.
Sure, I'm happy to set it aside.
It is an important issue.
Yeah.
I would love you to address the First Amendment issues,
Sure.
because I'm not sure many people think of this as a
Sure.
First Amendment issue. And then,
Right.
Carrie, if you can
Right.
respond.
So the first thing that I think we should flag here is you can't avoid the First Amendment by relabeling a claim as being about it's not speech, it's libel, or it's not speech, it's sedition, or it's not speech, it's contempt of court, or it's not a speech-based claim, it's a product liability claim. The First Amendment protects speech and speakers and publishers and distributors of speech against a wide range of claims. Now, it doesn't provide complete protection, but simply relabeling it doesn't avoid the First Amendment protection. So let's look closely at what the assertions here are. First of all, there's a lot of talk of addiction to speech, but if you think about it, if it's addiction to speech, addiction to constitutionally protected material, it sounds like people wanting to consume more constitutionally protected material, which generally they have a constitutional right to do, and people have a constitutional right to distribute to them. So just saying it's addiction, I don't think solves the problem. Yes, it's true that people can be, there are whole classes of items that are criminalized, drugs, because of their addictive properties and other related properties, but they're not protected by the First Amendment. Speech, content, videos, text, TikToks, and the like, they are presumptively protected. Now let's look at the particular harms, at least some of the particular harms we've seen. So eating disorders. So I take it the theory is that people watch enough videos of showing people praising ridiculous diets or talking about how important it is to be super thin, and then as a result, they end up following what they're doing. Well, this is a classic kind of case to which the First Amendment applies, right? If the argument is this entity, it could be the original speaker or the publisher, is distributing things that spread bad ideas. They spread bad notions, whether they're notions that you should eat too little, or they're notions that you should engage in violent jihad, or they're notions that, not in this particular instance, but in some of the lawsuits that we've seen against content providers, or the notions that life is not worth living and you ought to commit suicide. Rightly or wrongly, I think rightly, the Supreme Court has said the First Amendment protects even advocacy of bad ideas, because we can't trust the government, and that includes the court system and not just the legislature, to decide what are bad ideas and what are not. I oversimplify here, but that's basically the big picture. Now, of course, one might say, just one last thing, one might say these are children, right? So it's okay to restrict speech to children. That's a non-trivial argument. Justice Thomas on the court has actually made some powerful arguments in favor of sharply reducing the First Amendment rights of children to speak and to receive information. But in a case about 10 years ago involving violent video games, where in fact it was actually quite limited to specifically distribution of violent video games without the parents' consent. So it wasn't even a categorical risk of liability generally. It was subject to parental consent. The Supreme Court held, by a 5-4 vote, that children's First Amendment rights are sufficiently strong to prevent that kind of law, to render that law unconstitutional, even when the worry was violent actions by the children. I think it would be pretty hard to allow liability for the platforms allowing, for example, behavior excessively urging thinness and the like, even where children are present.
So I'm going to let Carrie respond, but I just want to let you all know I am now working in your questions, and Eugene read one from there. The question was, should there be special rules for minors? And so thank you for that question, and thank you, Eugene, for reading it from a distance.
For mind reading.
There was. I saw it.
A number of these questions will be things that we are going to talk about, so I'm just going to keep working them in to this conversation. Carrie, if you could go ahead and respond to
Sure.
Eugene.
You know, I think that if these cases were about the children searching for their own content and looking at it, then I think there would be a decent First Amendment argument. These claims don't relate to that. They relate to the product functioning, the algorithmic recommendations, which are the creations of the platforms. They relate to the recommendations. For instance, children if you create an account on Instagram and say you're 13, 6 of the first 10 people that you're going to be recommended as a friend are Kardashians, okay? Half the Kardashian family has been busted by the FTC for advertising, crappy diet products on Instagram. And yet this is what a 13-year-old's first friend recommendation is. And that's from the platform. It's not like they went and did a search for Kylie Jenner or something like that. It's the platform producing the recommendation. And these cases are about the platforms doing things like nudging and they've done in-depth psychological research on their users without their permission and figured out what types of things they could be presenting and how they can be measuring a user's mood to give them more content, because they know that kids who feel crappy about themselves are going to self-soothe on the platform and stay on it longer. The longer they stay on it, the more advertising is presented to them. And what is that advertising? It's more extreme dieting content. It's more recommendations. Oh, if you like these skinny people, then you'll really like this anorexic influencer and this content creator who's all about her recovery journey, which really is just about her constant return to the eating disorder hospital and her tubal feeding. It's on Instagram, it is actually a competitive environment for eating disorders and flaunting how many times you've been to the hospital and how many times you've had to get treatment. So, and we're dealing with people who are 13, who are vulnerable, who haven't developed coping skills, and that's just the people that are allowed, to be on these 13+ platforms. But really, we all know that it's even younger people. 8, 9-year-olds are on TikTok, and it can't get off of it, and it's just created like warfare in homes, and it impacts people. Like the damages are real and really addictive, and it impacts their sleep and their eating and their ability to concentrate in school.
So there are two things. I just want to pull out two things that you said, Carrie. So one is that I'm hearing maybe a tort, like in tort, it might make sense to have special duty of care towards minors. So that's part of it. I'm wondering, do you think that in response to Eugene's arguments about the First Amendment, is that, you're saying it's not speech at all, is that the key
Right.
for your argument?
Yeah, I mean,
Because it's algorithmic.
These are products, and part of the product is the design, the algorithms, the coding, and the things that are designed to keep eyeballs on the platform longer.
So if they just
Right.
read like a 17 magazine article saying it's great to be anorexic or something, that would be a distinct claim for you because you're dependent on this algorithmic
Well,
feeding.
that would be content-based.
But
Okay.
everything
So
you're
what is the
talking about is
algorithm?
content-based, right? Recommending, that's speech. It's speech of a particular content. Recommending somebody who talks in foolish ways about her supposed recovery journey, but actually is subtly pushing anorexia, that's content. It could be harmful content. You could argue maybe it should be constitutionally unprotected content. It's not currently viewed that way, but you could argue that. You could argue it should be constitutionally unprotected, notwithstanding the violent video game case when it is distributed to children. But it's all content. Likewise, if the concern is they have algorithms that keep people on the platform and keep people engaged, what does that mean? They have algorithms that provide to people content that they find so interesting, maybe wrongly, maybe they shouldn't, but they do find it so interesting that they're going to stay on the platform. That's the only way the platforms keep people engaged, right? Is by giving them content that they enjoy. If they recommend the Kardashians, that's an objection to content. Now again, one might say, well, certain kinds of content should be prohibited when it goes to children. And as I said, Justice Thomas, in the violent video game case, made a powerful argument that legislatures, and it would equally apply to courts, should have a broad, free hand in deciding what content can be given to children, especially over their parents' objections. But that's not where the court has landed, it seems to me.
Right, but there's a difference between the content. Yes, that's what's doing the damage. That is the nicotine-based. But there is, I'm talking about the pushing of it, the presentation of it. That is distinctly different from the content itself. It's the actually like making you look at it when you haven't even tried to.
Right, but the First Amendment does protect a right to listen as well as a right to speak. But by its terms, it most clearly protects a right to speak. The First Amendment doesn't just include the right of you and me to go out there and find things that we want. It includes the rights of other speakers and publishers to try to push things to us, right? It includes the right of somebody to put up an ad. It includes the right to put up a demonstration. It includes the right of a platform to say, look, if somebody comes to visit my site, I'm going to serve them what I think I want to serve them. That's a basic principle of free speech. Maybe there should be limits to that, but I don't think we can ignore the fact that the First Amendment most definitely does presumptively protect the right to try to push to your users those views, that content, those ideas that you would like them to see.
Let me ask you, do you feel that Amazon has the First Amendment right to sell suicide kits to children?
So I would need to know exactly what you mean by a suicide kit. If the answer is it's selling cyanide pellets, The answer is absolutely not, because while a discussion of suicide is protected, the shipping of physical goods, that is not expression.
Well, let me tell you what I mean then.
Yes.
Okay. So let's say, not let's say, this is actual truth. Amazon offers sodium nitrite.
Yeah.
$19, they'll prime deliver it to you.
Okay.
1 teaspoon of sodium nitrite mixed with water will kill you in 20 minutes.
Okay.
Throwing up doesn't matter.
Okay.
No way you can be saved. I know one person out of 60 families that I've talked to who has been saved.
Okay.
Okay. Amazon recommends that purchasers who purchase sodium nitrite also purchase an Amazon edition suicide manual with a chapter on how to die by sodium nitrite, anti-emetic pills that prevent vomiting, a personal use scale, and if you type sodium nitrite into Amazon's search bar, it autofills to say sodium nitrite suicide.
So I think the First Amendment actually draws a pretty sensible line here. It really does say there's speech, which of course also includes things like symbolic expression, wearing an armband, flying a flag, and physical conduct that is not expressive. So for example, actually shipping antiemetic pills, actually shipping sodium nitrite is not constitutionally protected. Now there are interesting questions of what happens if the lawsuit is over, they shipped this physical product and also this kind of speech. It's an interesting question. Generally speaking, you could be held liable for the product and not the speech. What if the speech is evidence of knowledge or intent? Interesting question. But what's doing the work here, and what's I think may lead to liability, at least in certain situations, is there's an underlying shipment of the device. Let's just take another example which is much more familiar to us. If Amazon ships you a bomb, it could be civilly and criminally liable if you then use it to bomb the local police station. But if Amazon sells a book which says the police are oppressors and we need to revolt against them, that's constitutionally protected speech. Could it lead to harmful conduct? Quite likely. In fact, most attacks on the police that are politically motivated indirectly stem from speech, because that's how politically motivated violence works. But the First Amendment law is quite clear. Selling the book is constitutionally protected, at least as I've described it here. Selling the bomb is not. Now, what if Amazon sees you are somebody who's really anti-police, so it starts giving you more and more anti-police speech. And then at some point, you actually do attack a police officer. You could be criminally prosecuted. Actually, this probably wouldn't be Amazon, it should be YouTube or Twitter or whatever. Should it be held liable on the theory that it was knowingly distributing anti-police speech that was likely to radicalize people? No, because the First Amendment protects the right to distribute that speech, even though it doesn't protect the right to actually distribute bombs, and it doesn't protect the right to act violently based on that speech. I think that's the pretty familiar First Amendment line. I think it's a sensible one.
And Carrie, in your cases, were the families or the people who committed suicide, did they receive the products? Is that part of the
Correct.
allegations?
So I represent the estates.
The estates, right. So you do have that piece that Eugene was saying is so crucial, that Amazon actually shipped out the products.
Correct.
Right. So maybe we have agreement that there could be liability. I got to get something that we agree on. All right, so I want to talk more about
And Amazon has not been winning any sort of First Amendment arguments on that case.
Right. I want to talk more about minors. I did receive a question about minors. It does relate to one of the topics we wanted to talk about today. And we do see a number of states passing new laws, and I think Congress is also considering legislation that would protect minors by requiring, for example, age verification for certain websites. And so the question I received is, don't state laws requiring verification of IDs for use of platforms like Pornhub essentially solve the problem of minors on social media platforms? So I think we'll take away the does it solve the problem and make this, is this constitutional and under the First Amendment to require age verification for these kinds of statutes? I don't know who wants to start.
So, I mean, this came up really recently in the Net Choice versus Bonta case in California, where the court said that it is not constitutional, not even like on a commercial speech level, for platforms to be required to age verify. And that relates to a California age-appropriate design law, which required a number of things, a number of reporting requirements, and everything across the board was deemed unconstitutional. A lot of the reasoning was that it wasn't tailored specifically, like the restrictions on the platforms were not tailored specifically enough to the harms that were caused. So in many ways, there was a preliminary injunction to the California's age-appropriate design code. And so it's not been absolutely deemed unconstitutional, but it's it's the road to being there. But I actually think that in many places, even though the decision is pretty scathing toward the AG that promulgated the law, I actually think it in many places provides a blueprint on how to do it correctly.
Okay, and what would that look like?
Just having more of a relationship between the conduct that you're trying to regulate and the harms. And fortunately, both the CDC and the Surgeon General have recently provided reports, and the CDC has a 10-year study that they've recently released evaluating suicidology and other youth risk behaviors. And so there's actually more content, like in the last 6 months, about the harms, also like from social media, and that can actually be used to improve these laws.
So there was a Texas decision, also very, very recent, where Texas had a law protecting minors, specifically from pornography, and this may be where the question was coming from. And that court also held that it was unconstitutional. Eugene promised me he'd do some real-time research on the stage, and so he is. So I just wanted to mention that is also has the procedural posture of a preliminary injunction, so it's still, not a final decision. But do you think that those kinds, when you say more content specific, do you think these laws that are focused more on pornography, or did you have a different kind of content in mind?
Well, it's interesting because the Communications Decency Act was originally, like almost all of it was about restricting pornography from children.
The other parts of the of the law.
And so in 1996, the Communications Decency Act passed, and in 1997, everything related to to pornography to children was deemed unconstitutional. So there's a history of there being some barriers to restricting pornography to children. I think that there's a really big difference between children consuming pornography, which is its own problem and situation, versus children being manipulated into performing pornography and into becoming the subject of pornography. And those types of things really, really do have to be addressed.
So I think there are three things going on here. So one of them has to do with the last thing that Carrie mentioned, I think we could put out of the way, which is what about essentially material that shows children having sex, and people trying to get children to have sex or to pose nude or in a lewd way in order to have images of that. Again, that is a serious crime under state law, under federal law. There is, in fact, the risk of federal law enforcement. I think what happens is most platforms don't get prosecuted because they know they're going to lose and that their staff are going to go to jail and the company faces financial ruin as a result. That's an important point, but it's a separate point from the second issue that's in play, which is what about pornography that is distributed to children? And the court had said in the late 1960s that it's permissible, back when this was just sale in stores or people going to theaters, It's permissible for a state to say, there's a certain kind of material that's constitutionally protected for adults, but not for children. And you got to card children who are coming to the store or going to the theater, at least if they look like they are young. However, indeed, in 1997, and then again, I want to say in 2003, the Supreme Court struck down statutes that aim at going after porn sites, that statutes that require porn sites to identify children or to try to block children from using it. For example, the sites might be required to have a credit card verification, and at least younger children tend not to have credit cards, and even if they do, their parents presumably can screen that. And the court struck those, as I said, struck those statutes down. It said that on the internet, if you're trying to promote parental control, the right way of doing it is by enabling parents to try to use filters, which in fact the market already does provide. You could imagine the government trying to promote that by, for example, making filtering software available for free to children and the like. The latter of these decisions was a 5-4 case. And it may be that the court was mistaken, maybe it'll change its view. But as of today, these kinds of statutes that aim to try to shield children from online pornography by requiring age verification are very likely unconstitutional given those Supreme Court precedents. And the functional reason why this is primarily so is if you have age verification, you basically have to have identity verification. And the court has recognized there's a First Amendment right to anonymous speech, including anonymous access to online material, including online sexually themed material. And a lot of people would find it very valuable to be able to access, a lot of adult people, to access porn online without having to identify themselves. The third question, which is lurking behind all this discussion, although not in the particular question that was asked, is what about shielding children from non-pornography? What about shielding them from, again, pro-anorexia speech or a wide range of other speech? And that is, in fact, what the CDC and the Surgeon General were talking about. I pulled up the Surgeon General's report, and it does say the influence of social media on youth mental health is shaped by many complex factors. Social media has the potential to both benefit and harm children and adolescents. That social media exposure warrants additional scrutiny. So there are reasonable people saying that there might, in fact, be substantial enough harms that might justify perhaps some regulation. But when it comes to non-sexually themed speech, the court held in the violent video game case that you can't restrict it when it's addressed to children. At least with regard to sexually themed speech, there's some precedent for restricting it, although the internet precedent is generally against that. But when it comes to supposed harms to mental health or supposed risks of youth violence and such, the precedent seems to be against that, at least unless the Surgeon General doesn't just say, well, it needs more research, but says, oh, yes, there is proof this particular kind of material is highly harmful to children. So I think that there's not a lot of future, at least under current law, for attempts to institute shielding of children. Again, you can imagine arguments that the law should be a lot more friendly to restrictions on speech to children. But that's not where the law is right now.
Carrie, one part of that California law that the opinion mentioned was that a way I think Instagram and other platforms might engage in this age verification is by using facial recognition technology. And I think the court was concerned that that might cause other problems. And I'm just curious if you share those concerns, do you think that it's worth the trade-off to have that verification possibility?
I think that, age verification seems to be a problem that tech companies have just had so much trouble contending with. And they usually say that, their defense is that, it would be a bigger imposition on users' privacy if they were to, verify ages or do facial recognition. And that might be true, but I do think it is disingenuous for these companies to care or express any sort of care or concern about users' privacy, just considering the amount of scraping and manipulation and analysis that they do on their users, and including their youngest users. So there may be laws that says that they can't share that information, but they certainly can use it internally. And for situations like Meta and Google, where they have a host of different products, they can use it, that information from product to product. But the thing is that most consumers, including children, are uploading their online products from the Google Play and the Apple Store. And I guarantee that those two places know the user's age. And I don't really think that there's been enough emphasis on putting the onus on the marketplaces where those products are available. And I personally am interested in looking at the seller negligence angle for the marketplaces on products that are really foreseeably dangerous, including to children.
But if the product is speech, and it's not porn, which as I understand it, I don't think Apple Store sells porn. If the product is speech that is dangerous because of its content, again, because of the ideas that it promotes, which may lead to physical harm, then I don't see a legal basis consistent with the First Amendment to say you, the Apple Store, or you, Google Play, have to block this. Again, in the violent video game case, the state law said if you are selling violent video games, then you can't sell to a minor without the permission of the parents, and the court said that's unconstitutional.
What's happening, though, is that we're not just talking about a speech-based product. We're talking about a product that is creating a compulsion to consume more and more and more and use it longer and longer. No one's arguing that exposure to some violent video games, exposure to some eating disorder content or porn is going to, limited exposure is going to significantly damage a child.
Lots of people are arguing that.
Okay, well, I'm not.
Okay.
It's the compulsion that these products are creating, where you've got kids who are using the products for 8 or 10 hours, that are using, stealing the phones out of their parents' rooms and using it all through the night. It's not that these are just products that are delivering speech. It's that they're creating a compulsion at the expense of other activities.
Yeah, so I'm always very skeptical about claims that certain speech creates a compulsion. So it's true that some speech leads people to consume it all night. I think most of us have had this experience with a very old medium, which is books. There have been times you've read a book that's sort of super into it, and you might even frame it, the publisher and the author deliberately decided to make this book addictive. They used various known psychological techniques to get you super into the book, and then you wasted a lot of time you should have been sleeping. Likewise, there used to be claims about this with regard to various television programs, that kids consume too many hours worth of that. Those are plausible arguments, but again, I don't see how they're consistent with the First Amendment to say, the content of the speech, because it is all about the content. It's nobody says, I got addicted to speech about, quantum mechanics, right? It's that there's certain kinds of content that is tailored often to the viewer, which is to say that the speaker, the publisher, thinks the viewer will really want to see, so it's giving people more of what they want, that leads them to want to consume more such content. I find it hard to distinguish that from standard First Amendment protected activity, which is giving people things, or giving people information, giving people ideas that they find compelling in the traditional sense of the word, compelling enough that they want to consume more of it. That's, I think, what the First Amendment protects.
I just think it's a little naive to think that the speech is what's compelling the addiction here, as opposed to the operations and the product design and the scrolling and the replay. And if a child was on YouTube and they had to keep, every time they wanted to look at a video, they had to search for it, that'd be a really different thing than if they're inundated with recommendations, and it auto-plays the next video. And that's what keeps them on. And
I'm going to, no, so there are a lot of other state laws being bandied about and sometimes passed, like making, they have to kick the kids off at certain hours or no algorithm. So there are lots of interesting things.
What does it mean, no algorithm? Computers don't function without algorithms.
I know. I'm just reporting.
Right, fair enough.
So we have a couple minutes. We have another question that is a topic that the Supreme Court is going to hear. And I just want to make sure for our audience, we offer a few words of wisdom on whether tech companies are common carriers where they could be required to post content they might otherwise want to take down. So you have 2 minutes to debate this and decide. Go.
Go ahead.
So these are the net choice cases that the court agreed to hear. They're coming out of Texas and Florida. They're complicated cases because there are a lot of details about the statutes, which I'm going to set aside. But the key question behind them is, are platforms more like newspapers or magazines, or are they more like telephone companies or large shopping malls? Or for that matter, universities deciding whether to allow certain recruiters. If they're more like newspapers or magazines, then they have a First Amendment right to say, I want to publish this and not that. And in fact, if you think about it, if you subscribe to the New Republic or the National Review, you're subscribing to them as much for what they exclude as what they include. If we were to say, oh, the New Republic and National Review have to be viewpoint neutral in their decisions, then they're not going to be the same magazine anymore. However, let's imagine a phone company. If a phone company says, well, we are a good American capitalist phone company, so if a communist organization wants to use our phone services, and it could be cell phones, so it's not a monopoly, it's a hotly competitive, it wants to use our cell phone services in order to promote, to have a call-in line for people who want to join the Communist Party, we're going to say, no, you can't use our property for that. The answer is that's illegal. They're common carriers. They have to carry everybody. Likewise, the Supreme Court has said if a state wants to have a law that says large shopping malls have to allow leafleters on their property, even if they disagree with the message, that's constitutional. The court said that in a case called Pruneyard. Or the court also said if Congress wants to say universities have to allow military recruiters, then that's constitutional as well, because that's not the university speaking or being the editor as with a newspaper or magazine. It's more like being a property owner, like the shopping mall. So that's the question, is do you view social media platforms more like a newspaper or magazine, in which case those state laws are unconstitutional, or do you view them more as like a shopping mall or a phone company, in which case they are? And maybe the answer is, depends on what you're talking about. If it's the platform's recommendations, they are speech, and the platform is entitled to pick and choose. But if it's just a hosting decision, then maybe they're more like the phone company or the shopping mall.
All right. Do you likewise?
Yeah, I mean, I don't really disagree with anything Eugene says, but it's not because I do agree with him. It's because I just don't really engage in my cases and in my day-to-day.
Fair enough, it's not where you live.
It's just like, it's not part of the litigation realm that I ever have to fight.
Right.
So it's just like I don't have a dog in the fight, really.
I will take as a concluding statement that I don't disagree. But I also don't agree. So I want to thank our panelists, Carrie and Eugene. Thank you so much for a spirited conversation tonight.
Thank you, Mary-Rose.
Yep. Thank you, Mary-Rose.
Thanks, everyone.